We're on the record now in 413 CR 3109. This is U.S. against Jamie Eugene Tuggle. This matter comes on for sentencing. Counsel, please remain seated, but now enter your appearance.
Your Honor, I'm Assistant United States Attorney Sarah Fullerton, representing the government. With me is Special Assistant Marty Klein.
Michael Hansen for Mr. Tuggle, Your Honor.
Mr. Hansen, may I confirm with you that you have discussed the pre-sentence report and any addendum with your client?
Yes, Your Honor.
That takes me to the question of a plea agreement. Is there one here?
Yes, Your Honor.
Yes, Your Honor.
Do you want me to adopt it?
Yes, Your Honor.
Yes, Your Honor.
Is there anything in the plea agreement that is inconsistent with the pre-sentence report or the sentencing recommendation?
No, Your Honor.
No, Your Honor.
I adopt the plea agreement. That takes me then to the pre-sentence report. My understanding is there are no objections to it. Is that true?
Yes, Your Honor.
Yes, Your Honor.
Counsel, I've got a question. The probation officer mentions in her sentencing recommendation something about a 2-level variance. I'm a little confused about that.
I don't believe he's entitled to a 2-level variance with respect to the prospective changes in the guidelines because he's a career offender, and the 2-level change would not affect the career offender guideline.
Well, that's what I thought.
And I agree with Ms. Fullerton, Your Honor.
Ms. Voss, can you explain to me what you were suggesting then?
That is accurate. What the two attorneys were explaining to you, as far as in our recommendations, what we're doing is if there are, these drug cases that these defendants are appearing, for in front of judges for sentencing, we are putting that language in all of them in regards to that 2-level reduction. However, as I stated in my recommendation, Mr. Tuggle does not qualify because of his career offender status, and so that's what the recommendation says. We just are including it just so everybody's aware that it wasn't omitted, and so I guess that's the best I can explain it, unless you...
No, that's fine. I get it. It's form language that got stuck in there, and that's fine.
Yeah, basically canned language we're using. And then we're just indicating if the person does not qualify, then we'll explain why that is. And if it's a case where it's not even a drug case, then it will not be in there at all.
Okay. Thank you.
You're welcome.
All right, counsel. Let me go over the guidelines with you. This is pursuant to the sentencing recommendation that was provided to you on July 22nd, 2014. We have a total offense level of 31, a criminal history category of 6. The guideline range on count 1 is 188 to 235 months. With respect to count 2, my understanding is there is no actual guideline computation. I am to essentially do an analysis under application note 3C1.3 to determine the total incremental punishment. But whatever punishment that I impose under count 2 must be consecutive to the punishment imposed on count 1. The supervised release range is 4 years to life on count 1 and 1 to 3 years on count 2. The defendant is ineligible for probation. The fine range is $15,000 to $5 million. The restitution amount is There's no monetary restitution required, and a $200 special assessment must be paid. Have I accurately stated the correct advisory guideline calculations?
Yes, Your Honor, there's also a forfeiture of $301. I think the preliminary order's already been entered.
Thank you. Just a moment, please. Yes, and there's a forfeiture required of $301 in currency. Do you agree that's the correct calculation, counsel?
Yes, Your Honor.
All right, thank you. Are you prepared to proceed to sentencing at this time?
Yes, Your Honor.
Yes, Your Honor.
Let me hear from the government.
I'd recommend a total sentence of 188 months, Your Honor.
Which is what the probation office is recommending.
Yes, low end of the combined guideline range, yes.
Thank you, counsel.
Judge, we are asking for a sentence as recommended by the probation office with the additional recommendation that Mr. Tuggle be placed at United States Penitentiary in Tucson, Arizona. Mr. Tuggle graduated from high school in the Phoenix, Tucson area. He has family there, so he would ask to be placed at Tucson to be closer to his family.
Sure, I'll make that recommendation.
Thank you, sir.
Mr. Tuggle, you get the right to speak. You don't have to say anything, but now's the time to speak if you like.
No, thank you, Your Honor, not at this time.
To reflect the seriousness of the offense, to promote respect for the law, to provide for just punishment, and to afford deterrence, recognizing that the guidelines are advisory and considering the statutory goals of sentencing, I now sentence you to 164 months on count 1, 24 months on count 2, those sentences to be served consecutively. I recommend that you be placed at the facility at Tucson, Arizona, so that you can visit with your family. I impose a 5-year period of supervised release on count 1, a 3-year period of supervised release on count 2, those terms to run concurrently, but pursuant to the standard conditions together with the special conditions outlined in the sentencing recommendation. I don't impose a fine. There's no monetary restitution required. I do require you to pay the $200 special assessment, and I do finally forfeit to the United States the sum of $301. Counsel, that is my judgment and sentence. Do you have any questions?
No, Your Honor.
No, Your Honor.
Do you wish any further elaboration of my statement of reasons?
No, Your Honor.
No, Your Honor.
Mr. Tuggle, it now becomes my obligation to inform you of your right to appeal. If you want to appeal, you've got to do so within 14 days of today's date. Appeal means to have a higher court review what I've done. It's not hard to appeal. You write down on a piece of paper, I want to appeal, and file it in the court file. Your excellent lawyer will do that for you if you tell him to do so. My court clerk must do that for you as well if you tell her to do so. In a moment, we're going to take a recess, and that's the time you can speak to the court clerk. She'll hand you a piece of paper that summarizes your appeal rights, and that's the time you can talk to her. If you perfect an appeal, a higher court will review what I've done, provide you with a free lawyer, and not make you pay money to appeal. But as I say, you have to file the notice within 14 days of today's date, or you lose your right to appeal. Do you have any questions about your right to appeal, sir?
No, Your Honor.
Is there anything else that we can take up at this time?
No, Your Honor.
No, Your Honor.
Do you have any questions, sir?
No, Your Honor.
We stand in recess.
Thank you.
Sir,
Thank you.